bheki-ke lokhu okuthize yena-ke akufunayo, kodwa-ke akabheke konke lokhu engikhulume ngako. Yingakho-ke besibuka le y'thombe ebesiyibuka-ke lana, ngoba-ke ingafuni-ke ukuthi-ke isithombe esithizeni esizotshengisa lokhu-ke akufunayo, kodwa-ke asiyibuke siyibheke zonke iy'thombe.
Thank you, Brigadier. Now, I heard you saying in your testimony, again, I can't remember whether it was in cross-examination or in your evidence in chief, but it was in this session, not in a trial within a trial, it was in this session, where you made mention of the fact that you were not aware about the testimony of Mrs. Pinky Vitilinga, not so?
My Lord, what I've said is that I was not in court. That's how I recall the events. That I'm aware that she testified, but all I said is that the actual words that she used when she was in court, because I was not in court, my Lord. That's what I've said. It was in that context.
Ngaye uPinky Vitilinga ukuthi bengazi ukuthi-ke uzile enkantolo ezokuthula ubufakazi, kodwa-ke ngangekho-ke la enkantolo ukuthi-ke ngazwe noma ngizwe ukuthi yini ayisho la enkantolo.
Thank you, Brigadier. Actually, you said, I'm just paraphrasing you. You said you were not aware of the cell phone records of accused number of the cell phone records of accused number 3, not so?
No. So let's put it in the right context, my Lord. I've said, prior to Ms. Vitilingham coming to testify, I was not aware of the cell phone records that covers the period of 26 October 2014.
Yes.
We had cell phone records that I think were starting in November going upwards, and I said when she was in this court, that's when I became aware of those cell phones, which were then subsequently made available to us, my Lord. Cell phone records, sorry.
Engikushilo-ke ukuthi-ke ngangingazi-ke ngawo-ke ama-cell phone records akhe-ke umsola wesithathu mayelana nesikhathi-ke 26 October 2014, kodwa-ke kuzokwenzeka lokho ukuthi ngazi-ke nkathi-ke eselana enkantolo ethula ubufakazi bakhe-ke yena uMiss Pinky Vitilinga.
So the first time you got to be aware that there are cell phone records which cover the period also of the 26th of October 2014 as they relate to accused number 3. It was when Mrs. Vitilinga was testifying in court.
My Lord, when I said when she was testifying, so how it works, an advocate Mnisi knows, there will be a consultation with the state advocate, and then obviously then the witness will testify. So I'm saying it was around that period, prior to her coming to give evidence in court, I was not aware. So I was aware around that time when they were consulting with state advocate, that it was then somehow brought to my attention that there is new cell phone records that relates to the specific date of the incident, because we didn't have, my Lord. That is why if you look at the request I gave to Kenneth Stein, nowhere does he cover the period of the 26th of October in his analysis 2014, my Lord.
U-advocate Mnisi uyakwazi-ke lokho ukuthi kusebenza kanjani-ke ukuthi ngaphambi kokuthi ufakazi-ke eze enkantolo ezokuthula ubufakazi bakhe-ke ukuthi uhlala phansi-ke nombuso enze lokhu okubizwa ngokuthi phecelezi-ke i-consultation. Manje ngithi-ke mina-ke ngikwazi ngaleso sikhathi-ke ngokuthi ngaphambi kokuthi aze enkantolo ezokuthula ubufakazi bakhe-ke ukuthi kwakusenala amarekhodi amasha-ke manje ama-cellphone sondele kulesa sikhathi lesiya sange-26 October 2014, kodwa-ke kuyena-ke uKenneth Stein lokho angizange ngikuthola, kodwa kuyena uPinky Vitilinga.
Thank you, Brigadier. Let me ease your mind. The records of accused number 3's cell phone, as they also cover the period of that 26th of October 2014, had already been disclosed to the defense at the very inception of this trial. So it strikes me very strange in terms of the nature of your investigation to say that you were not even aware of those records.
No. That cannot be correct, my Lord.
For a different case,
yes. I mean, I can remember the evidence.
Yes.
But not for this case.
Indeed.
Different case.
The records that were disclosed as the witness testified were those ones from from November 2014.
I did not get the gist of the objection, my lord, about the disclosure of
Yeah, they say the objection is not clear, Mr. Baloyi.
Yes, indeed.
maybe I did not hear the statement. It was something distracted me.
Well,
Yes.
the proposition that the cell phone records of accused number 3 covering the period 26 October 2014 were already disclosed at the time when there was a general disclosure. We objecting to that, and the basis of the objection is that that is not correct, my lord.
As it is a court, my lord, it is incorrect to say that those records were already disclosed to the defense at the time when Mrs. Pinky Vitilingam was testifying. I became aware of that Section 205 record when I was preparing for this trial. And they were contained in Cleveland case in yellow pages. Now the question is, if really this case was investigated to the manner in which it is to be assumed that it was investigated, how can then Brigadier Gininda say that he was not aware about this so important piece of evidence when it was disclosed to me, I think last year May? Thank you, my lord. That's the question that I'm directing to the Brigadier. I don't know if the state would also want to clarify that as well.
My lord, that cannot be true. It's absolutely not correct. I think one can even take it to the greatest form that it is misleading to say that, to say the least. It's not true, and if that is assertion that it is the truth, then it's misleading. Because the docket is indexed, my lord. When you get evidence, you index it. What was found initially, my lord, and I know we dealt with this part with the forensic team and the state advocate, was that the first records that were applied for, insofar as the Cleveland case is concerned, Advocate Mnisi is correct in that part, only started in November. I think that's why he's making November. Those are the ones that we were able to discover during the course of the investigation, and those are the ones that were disclosed to them. We had no knowledge of the second bunch of records. Why did we have a knowledge? Did not have a knowledge, my lord? They were applied differently. Even if you look at the reference number, or you call the case file, the first bundle that we disclosed had a different case file than the one that was discovered by Pinky Vitilingam. So it was not records that were available. For some reason, my lord, they were kept away from us. It is through the exercise with Pinky Vitilingam when she was asked to conduct a search on the number that this other set came up. When it then came up, my lord, that's why I referred that it came up around the period of consultation and subsequent to her evidence. Then, during that time, my lord, they were then disclosed to the defense for the first time, and we filed them in the docket. So the assertion that they were given to the defense prior to the commencement of this trial, my lord, if they have it, then they don't have it from us, my lord, because the docket does not have such a recollection recordings, first of all, and that goes to the cell phone analyst, Kenneth Stein, who analyzed these records. That is why, my lord, the person who dealt with this is Kenneth House, because they came around during his period. Kenneth Stein did not have access to this, and the court will recall that part of the exercise that I've asked him to do when Kenneth Stein started as a cell phone analyst, my lord, was the following, and I've dealt with this part. First, I said, this is what is contained in the docket in terms of the cell phone data. Authenticate it. Secondly, I said, he, as a cell phone analyst, because I'm not an expert, he must go and authenticate what we have in relation to what he finds in the database of the police and the service providers. And he came back and said, what we have here, this is what I have, so I can authenticate it. Nowhere, my lord, even himself, was he able to discover these records that mysteriously were kept hidden somehow, my lord, and surfaced when the expert then came to testify. So that assertion is not correct. That is how things unfolded, and they were authenticated. They were not there. So we investigated, my lord. They were not made available. They were not in the face of what we would have uncovered during the investigation.
Kuloko akushoyo-ke u-advocate-ke ngasho ukuthi kona-ke akusona-ke iqiniso, ikona-ke esengaqhubeka ngiye phambili ngithi-ke ikona-ke okukhohlisayo ukuthi-ke bakuthola bona-ke ngaphambilini kwesikhathi lama records amasha uPinky Vitalingam akhulume ngawo abawatholanga kuthina-ke singamaphoyisa futhi-ke lokhu kuzovela-ke ngesikhathi sakhe-ke uLieutenant Colonel Post ngesikhathi-ke ngicela yena-ke uLieutenant Colonel Stein le mininingwane noma-ke le information wayengenayo-ke imininingwane leli eyayigodliwe-ke kuthina noma-ke sasingazange siyinikwe-ke kodwa eyazovela-ke uma ngabe yena-ke uMiss Pinky Vitalingam esethula ubufakazi bakhe.
As it pleases the court, my lord, I'm going to request for a short adjournment. I mean, it's almost 20 minutes to lunch time. I'm just about to wrap my cross-examination. However, I still need to pursue this point, my lord. I want to introduce those, that record that is being disputed or denied by the state, that it was made available to us at the very inception of this trial, actually even before the accused were made to plead to these charges. I want to introduce it as a fact, something that is tangible. So I would request that we take an early adjournment, so I'll go prepare them and then I'll come present them at 2 o'clock, my lord. When I come and finalize.
We've got a list here of all the exhibits in this trial. Don't we have some? All.
Yes, there
And
is
then
a
they
list
go
of
from
exhibits.
1, I think, up to 170 something. What was the citation? Meaning, in other words, Mr. Mnisi, the very record you say was disclosed,
Yes.
it will be in the exhibits which are given to the court. Unless I was not given that exhibit. If I was given that exhibit, there is a list
Yes, ma'am.
where you just have to read the list and you see
Yes.
evidence of so and so.
Yes.
Yeah, so what's the problem? Why should we not just go and inspect that
Madam,
list?
with due respect, madam, I'm not talking about the list
What are you talking
of
about?
exhibits that had already been handed over to court. I'm talking about disclosure, the information that was handed to us by the state when we were supposed to prepare or when we had to prepare for the trial. I'm talking about that information.
I hear you. Are you saying the state used evidence which they never disclosed? To the court, in other words.
No, my lord. I
What are
never
you
said
saying?
it. I am saying, my lord. I am saying, my lord.
Yeah.
Because the brigadier said in his evidence
Yeah.
that he became aware of the record of the cell phone record of accused number 3 upon the testimony of Mrs. Vitalingam. And then I'm saying to him, no, but it cannot be so because we already had that record when we had to prepare, when we had to start to prepare for this trial. In other words, that record has been there even before Ms. Pinky Vitalingam could come and testify. And then the brigadier says no. Then if we have that record, they don't know where we got it from.
Okay, that's agenda.
Thank you, Manu.
Just before adjourn, just so that there's no misunderstanding, the Brigadier refers to the cell phone records of accused number 3 that covers the period 26 October 2014.
I'm talking about that as well. Thank you.
Which records are supposed to have prescribed?
Well, the records were there. They were asked by the previous team, Manot, in the other case, but not disclosed to
Okay, fine.
the current team.
We come back at what time? 2 o'clock.
All right.
Okay.